Welcome students. We will see today the new developments in the IPR. In previous session, we have seen patent rights, scope, then nature of intellectual property. Also, we have seen what is the licensing, technology transfer, and how we can utilize those two to protect our innovations. Then patent information, what is patent information and patent database, and what are the documents and what are the contents of those patent documents is included. These details we have studied. In this lecture, we will see administration of patent system. Some of the things are again repeating because this is a vast topic and we have already discussed some major points related to patent and copyrights. So still we will revise some of those things. So we'll start with administration of patent system. Then the new developments in the IPR. So what new things are included, what are the developments in the IPR, those things we'll see. Then traditional knowledge case studies. So few case studies we will go through, just overview. So administration of patent system, what is that? It means when any person or any innovator researcher files a patent, and after filing a patent and after the defined duration of 18 months, the patent is granted after rigorous evaluations. It should be administered and exploited. So once the patent is granted, it should be administered and exploited. So patent administration deals primarily with the monitoring and execution of all actions which are necessary for maintenance of that patent, like payment of any annual renewal fees and all that. So the work of this administration team is that monitor and execute all the actions related to the patent which is granted. So in that, the annual payment or annual fees of that particular patent filed person, that should be taken care, as well as the protection of that particular patent is monitored. So this is a primary thing, responsibility of administration. In the context of patent management, all opportunities should be used to profitably exploit a granted patent. So it should exploit all the profitably exploit or profitably opportunities to for a granted patent by the patent owner himself or by the third parties. That means like licenses, patent sale, etc. Some persons who does the job for some of the innovator or research. So they should do this thing. Uh, the organizational structure of this patent institutions is shown here in this figure. This is taken from the Office of the Controller General of Patents, Designs and Trademarks, ipindia.gov.in. So from that, this structure is taken for this presentation. You can see at the top, Office of Controller General of Patents, Designs and Trademarks. So this is Office of Controller General of Patents, Design, Trademarks, and this is divided in different verticals. So the first vertical you can see here is Rajiv Gandhi National Institute of Intellectual Property and Management, that is RGNIPM and PIS, and it is located in Nagpur. So this is one of the National Institute of Intellectual Property and Management System. Then the patent offices are at 4 different metropolitan cities. Like the head office is located at Kolkata, and other three branches are in Delhi, Chennai, and Mumbai. So the four metropolitan cities in India, where the patent offices are located. Now there is only one design office or patent design office, you can say, which is located in Kolkata. There are five trademarks registry office. So patent offices are at four locations, design office is at one location, and trademarks registry or registration office, you can say, are located in five offices. So head office is at Mumbai. Then other four locations are Delhi, Kolkata, Chennai, and Ahmedabad. Related to the geographical indications registrations office or registry, which is located only at Chennai. So design office is only located at Kolkata, whereas geographical indications registry office is located only in Chennai. Then SCI/CLD registry office is located in Delhi, and copyright registry is also located at the same place, that is Delhi. So mainly you can see here patent offices as well as trademarks registry offices are located at four or more locations, and design, geographical indications, and copyright offices are located at a single location. So this is the overall organization structure of the patent institutions in India. Now, what are the recent developments happening in IP laws in India? That is intellectual property laws. So it is important for India to protect intellectual property rights. Already we have discussed these things. What are the benefits of protecting the IPR? Not only this, but it also helps in the international market to achieve exclusively over the distribution and production of the same. That means whatever intellectual property is there, if it is registered and protected at the international market also, it will achieve exclusive distribution and production of that particular IP. And for that, what the government has done, so the Indian government took very leaping or very stepping stone steps by showing its commitment to the WTO under TRIPS, that is Trade Related Intellectual Property Rights Agreement. So this is very significant step taken by the Indian government. And what has done this, or what are the outcomes of that? So this agreement made sure that the position of IP laws in India is accepted on an international level. So whatever IP laws are defined or set by the Indian government, so those are accepted at the international level also, and that is due to the TRIPS agreement. So what are those developments? We'll see one by one. So first we'll start with the trademark, and already we know that trademark is a sign used to distinguish the goods, services of an entity from other entities. So it is a sign used to distinguish the goods and services of an entity. Its essential function is to present the origin of the goods to which it is attached or to which it is used. So what is its main function, for what purpose it is generated or produced, or for which purpose it is used. A trademark portrays the quality and nature of that product, and the government of India replaced the Trade and Merchandise Marks Act of 1958 with the Trademarks Act of 1999. So earlier there was a Trade and Merchandise Marks Act, which was set in 1958, but that was replaced with Trademarks Act of 1999. So the currently is this act is in place, and this was done to bring the Indian mark trademarks law in persistent with the international practice. So whatever international practices are there, to cope up with that or to persist with that, this has been done. And the significant changes under this act are, some of those acts are given here. So for the first time, service marks were introduced for protection through the registration. So, earlier service marks were not there. So these were introduced for the protection purpose through the registrations, trademark registration. Then shapes, graphic representations, color combinations were included in the trademark definition. We have seen examples in the previous session that it may be trademarks may have some shapes or some colors. Orange, I think we have seen in that last session. Then representation and color combinations were included in the trademark definition. The trademark registry issued an order allowing alterations in the applications for trademark registration, which included substantially alterations which would not be allowed. So, al- allowing alterations in the applications of trademark registration, which included substantial alterations. So earlier substantial alterations were not allowed, but it is now allowed. Other alterations include clerical alteration, which would be accepted by the registrar. The registration period was also increased from 7 to 10 years. So as per the 1958 Act, the once the registered trade, trademark will be valid for 7 years. Now, after the 1919 Act, it is up to 10 years. The new law allowed both registered as well as unregistered trademarks to be assigned with or without the goodwill of the business. So they allowed or the registered or unregistered trademarks to be assigned with or without the goodwill of the business. Now, what are the developments in geographical indications? First, we'll revise that geographical indication is a sign used for associating certain products with a geographic location or origin, and the quality of product identifies its origin. And there are a lot of examples we have discussed. Like one of the simple example is oranges from the Nagpur, or chappals from Kolhapur, chadars from Solapur, or Alfonso mangoes, or basmati rice, Hyderabadi grapes. So these are some examples. And the act of this, that is India enacted the Geographical Identification of Goods Registration as well as Protection Act. Again, it was in the year of 1999, which provides for registration and better protection of GIs for products that would ease up the identification of goods that associate with the quality, place of production, quantity, or any other characteristics of such goods. And example of such goods are like Darjeeling tea, Alfonso mangoes, basmati rice, Hyderabadi grape, or Nagpur orange, Kolhapuri chappals, Guntur mirchis, and all this. And this makes them stand different from the other products in the market and makes the such requirement of protection indispensable. So this GI protection helps the geographical uh, products to protect from different products in the market of same area. Now the third type is copyright, and the developments happened in this law. So copyright law protects the original works of an individual author, composer, artist, work or major cultural industries, film, recording, or broadcast industry, as well as computers and software industries. And in India, the copyright is governed by the Copyright Act of 1957 and copyright rules in 2013. And but these are not fixed. Various amendments have been made up to date till now. So in 2012, amendments were made to the copyright law, which made the Indian copyright law in accordance with the WIPO copyright. So, World International uh, Indian copyright law has been modified as per the WIPO copyright treaty, that is WTC, and WIPO performance and phonograms treaty. So it provided unique provisions for fair use, provisions for the disabled, and amended author friendly changes, etc., and which made sure that fair usage survives in the digital age. The Indian government notified the copyright rules or amendment rules in 2021, amending the copyright rules 2013, and this was done to encourage transparency and accountability. So it helps in the transparency as well as accountability of the particular work done by some author or composer or any person. These new provisions were introduced to deal with the undistributed royalty amounts and the use of electronic and traceable payment methods while collecting and distributing royalties. So these provisions were introduced to deal the undistributed royalty amounts because sometimes some persons use some other author works or composers work without giving the credit or royalty to them. So this amendment made in 2013 helps so that the original author or composer can get or can collect the payments which would he would have got from the user. Now, patent law protects the exclusive right of patentee, that is patent holder or the one who has filed the patent and one who got the patent, which enables him or her to obtain commercial benefits from his or her innovations. So it protects exclusive right of the patentee, which enables him or her to obtain the commercial benefits from the inventions they have made. This right stops a person from manufacturing, using, or marketing the invention without the permission of the patent holder. So the third person cannot use the innovation to manufacture, to distribute, or to produce without the permission of the patent holder. So that is given under the patent law. Again, here also some of the amendments have been made in the patent law under the Patent Amendment Rules 2020, and these are the revised rules in 2020, which came into force on 20th October 2020. Before the 2020 revised rules, the patentees and licensees were supposed to submit statements of commercial working for each annum. So earlier, one has to submit the statements regarding commercial working of each annum. And the revised rules is the filling of statements commercial working of a patented invention for every financial year, as the income statements in the India are generally generated for financial year. So whatever earlier it was per annum or yearly, current with the revised rules also it is currently only, but considering the financial year as 1 April to 31st March. So the patentee has to submit the statements of commercial aspects of the patent. The development of these intellectual property laws is of significant importance, and these developments will also take place in coming days. This is so we'll see some more amendments will be made in some of these laws, patent law, design, copyright, or trademarks, trade secrets. Therefore, it is necessary to make people aware of these developments and changes. So one should be aware of all these developments and amendments, changes in the laws. Lack of awareness can lead to unintentional infringement of these laws. So if someone don't know and he may take the role without any intention. So awareness must be there among the people or among the innovators. Spreading awareness can be done through print media, digital media, and providing updated knowledge about the developments in schools, colleges, universities, or through the webinars, conferences, local programs. Now, we'll see intellectual property rights of inventions in biological science. There is a one article. We'll just go roughly in this. The title of this article is Intellectual Property Rights of Inventions in Biological Science. And if we go through the abstract of it, we will come to know intellectual property rights are provided to an author by the government to protect his intellectual rights towards society. It grants the inventor an exclusive right for a certain period of time for proper use of his creation. So it grants the inventor an exclusive right for a certain period of time for a proper use of his creation. It's in different, like patent is having different validity, design is having different, grades are different. Intellectual property includes patents, trademarks, copyrights, trade secrets, designs, industry design. Since last few years, many controversies have raised on biological patents, so this is important. Since last few years, many controversies have raised on biological patents, and patenting of exacts from indigenous plants, animals, and organisms already known to indigenous people has been called biopiracy. And still, people are not aware in terms of what invention of, or the technology can be protected or patented. Therefore, present review deals with the knowledge that gives us the insight to handle with our intellectual property. So, the last point in the previous slide, we discussed that there is a lack of awareness among the people. So, due to that, what happens? There is a possibility of biopiracy because of the unintentionally this happens and they unintentionally. Why? Because they don't know about these amendments or changes. Now here the authors have tried to make or review the IPR related with the biological sciences field, and they have given here, they have started here what is IPR, IP, and then what is IPR, and then regulations and managerial actions concerning to IPR content, their heritage in Europe, England, and different places. Then they have done the literature review and given a detailed sequences of things or progresses happened in the IPR of biological sciences. What is important here? That is, IPR is a solid device to defend states of era, wealth, and efforts by the originator of an IP, and it gives a worker an elite authority to employ his innovations for certain phase of time. That is, for the validity of that particular protection. Society also gets benefits from the IPR, and it is mainly grounded on two conventions, that is, inspire discoverers to devise, authors to write, and second one is greater the inventions or processes related into the public domain, public benefits and also quality of life is enhanced. So, how this IPRs have helped to the society? One is it inspires discoverers or innovators to devise and work on the innovations, or the authors to write, or the composers to compose new things. And second is that greater inventions or processes released into the public domain. So once this innovations or trade are released into the public or society, then public also gets benefited from those products or innovative products, and it will also enhance the quality of life. Not only this, it also helps in the financial growth of a nation via vigorous struggle and inspiring forma- formations and invention in the monetary expansions. So not only the society help, it also helps in the financial growth. Now, role of confidential information in IPR and controversy, and this is important because before getting a uh, before a patent is granted, if the information is leaked, then it is difficult to get the grant patent. So that is discussed by the authors here, and then here what are the types of IPR? Already we have seen this in detail: copyright, trademark, patent. Then what is protection, benefit of the registrations, and for what time it is valid. So under copyright, we have seen original works of an author include books, articles, motion pictures, creative idea. And benefit of registration is it provides person with legal evidence and public notice of ownership, so that if author cannot claim that this is my work if he has not registered for the protection purpose. If he has registered, then he can claim that someone is using his or her art or work for benefit of their, and validity is for lifetime plus an additional 70 years, and it cannot be renewed. Then similarly trademarks and patents also. So we'll not see, already this is discussed, and but you can go through these articles because this is related with, or the examples are related with the biological science. Now here one table depicts that patents published in life science globally over last few years. And here see the product or process is related to the method of penicillin production. And the inventor is Moyer, and this is the patent number US 244241118. And what is that patent? This invention resulted in high production of penicillin. Microbiological assay method used for measuring content of the penicillin is very slow. So much of the penicillin disappeared till the assay provided results. But due to this process, we get correct amount of penicillin and it lasts for long time. So this is the description of that particular patent. Also, we can see another example, that is microwave oven for treating foodstuffs. So this is invented by the Spencer in 1950, and this is the patent number. And what it does, microwave everyone knows, but this is in the 1950s. So that time the description one would have given like that: it is an device or object which provides an efficient method of using electromagnetic energy for cooking or foodstuffs, so to keep the food hot and fresh. So for such purpose, one can use this device. Then artificial heart, laser. So these are all the inventions, and what those inventions are given in this table. Some more are given here: wax emulsion, a malaria vaccine, HIV protease, hepatitis B vaccine, and these are all related with the biological sciences. Here, the authors have done a review of literature, extensive review of literature, you can say. And process flow of a typical patent. So already we have seen this in the last video, that what is the process. 1 to 3 months, then 12 months, then up to 36 months. So you can go through this article so that you'll get some clear idea about IPR in the biological science. Here we will see some case studies on intellectual property. This is the official website of Filco. So here you can see case studies on intellectual property. So here you can observe the title, the country or territory, and the case study or the IP is related with which industry. You can see a bold step into the modern economy. It is developed by the Philippines, and the related field is farming and fishing. A brand wrapped in success, food production restoring bonds. A color for all seasons, design as a clear as water. So here just will go, and this is developed by the Panama, and it is the industry is related to the beverages. So we'll just go through, click on this. Then what you'll see, a title, a design as clear as water, and Panama Springs, SA Panama. So it is situated on the isthmus of connection of continents of South and North America. Description is given. So goods with the specific geographical origin and research and development, what they have done, and industrial design. So this is their product, Panama Blue, and it is produced by in different sizes and is protected by the IP system, Panama Springs. Now, if you see some other example, a painless needle. It is related to biological sciences, healthcare, equipment, and tools. They are developed by the Japan. You just go through Teramo. For diabetes patients, daily injections are an uncomfortable and often painful part of life. And with multiple injections required every day, anxiety and fear are typical emotions of a patient may have were diagnosed with diabetes. So this is the background about this invention and what is they have done. That invention is given and research and development carried out to develop this painless needle is given here. Then how they are commercialized and what are the social issues, business results, all things is given here. So all these are different case studies. Building on a foundation of IP, India, pharmaceuticals and biotechnology. This is file patented by Ms. Mazumdar Shaw, Biocon's founder. The biotech queen from Bangalore, India's first lady of biotech, the mother of invention. So this is about Kiran Mazumdar Shaw, chairman and managing director of Biocon Limited. And What was their invention? Bicon's early success was attributable to its enzyme manufacturing. The company's breakthrough came in the 90s, where it invented a new fermentation on technology to replace the conventional tray-based culture of microorganisms. So they invented new fermentation technology. So here, what the research they have carried out is given, and related to that particular patent, it is mentioned in the patent information. Electrifying an Indonesian brand. Is it's related to Radix guitars Indonesia. So it is related to the Indonesian guitar design. So there is an invention related to alternative energy or durable household products, which is named as FUSE. It is electric car conversion for sustainable mobility. And electric vehicles are partly touted as our inevitable future transportation solution. And this first viable prototype was invented in 1887 by William Morrison, related to EV, and a Scottish chemist living in USA. He latched 24 massive batteries to a horseless carriage and set it running. So that was to prove the concept. So you can go through this link, it is provided in the PPT. Xiaomi Corporation that is promoting the better life through innovative technology. We have seen this product, how it has evolved in the last 1 decade in India or even all over the world. The products they have developed here the list. So you can go for your personal interest as well as for better knowledge. There is another link That is case study on intellectual property rights. So here it is. S. Victor Whitemill versus Warner Brothers Entertainment. So S. Victor Whitemill, a tattoo artist, filed suit against Warner Brothers for copyright infringement due to their use of a tattoo he created for Mike Tyson. So Warner Brothers have used a tattoo as per S. Victor Whitemill, which was subsequently depicted on a fictional character in the Warner Brothers film The Hangover Part 2. Warner Brothers, on the other hand, argued that their use of the tattoo was in the spirit of parody and thus was covered by fair use. Ultimately, Whitmill's desire for an injunction against the release of this film was denied, and an agreement between the two parties was made out of court for undisclosed terms. So they have done the agreement, and it was disclosed outside the court. Then second case, you can see here, National Biscuits Corporation versus Kellogg Corporation. So what happened here? National Biscuit Co. filed suit against Kellogg Co. over their sale of shredded wheat cereal. And according to National Biscuit Co., Kellogg's manufacture and sale of this product constituted unfair competition and trademark violation. And since the previous iterations of their company had been owned by the inventor of shredded wheat and the machinery used to make it, although the patents on both the inventions had been allowed to expire. Kellogg countered with argument that National Biscuit's suit amounted to an attempt to monopolize the market on shredded wheat. Ultimately, US Supreme Court ruled that shredded wheat was not a trademarkable term and its design was functional and thus free of copying since the trademark had expired. One other case is also given. So these are interesting cases. You can test the as interest. So these are some of the case studies on the intellectual property. So you can go through these slides related to the administration of patent institutions and structure that are the which body is located at which place and the developments occurred in India in intellectual property laws. We have seen one by one, that is trademark, geographical indication, copyright, patent, recent developments. Then intellectual property rights of inventions in biological science and some of the case studies. So it is better if you read or go through some of the case studies so that you can write this if the question arises, or you can explain, or it may be useful for you if you are filing for a patent of your own innovative product. So that ends about this. I hope these PPTs and these video lectures will be helpful for you. If you have any queries, you can always ask. So once again, we will see there is one more article. Just I will go through it. It is related to the computer software. Okay, what we have seen about biological science, and one more point is there in the syllabus, that is intellectual property and computer software. And here it is given with what is what are the main two types of software, that is proprietary software and cloud, and legal background that is related to the IP and computer software, growth and critical issues, and further policy implications. And this is a big article, but you can go through the summary here and what this report is all about. And This is related to examine a range of economic, political, and developmental issues connected with the use and expansion of computer software in countries of the South. And it examines wider conceptual economic and intellectual property law implications and practical consequences of two main software formats, that is predominant proprietary format and other one is FLOS, that is free or libre or open source software. So you can go through this executive summary, or if you have time, you can go through the detailed article also. So you can see that IPR of biological and IPR of computer software. So for these two, you can refer those two PDFs. It will be uploaded on the Moodle. And other things are given in the PPT, or you can refer this book or Kothari book. And most of the points related to the patents and types of patents are covered in the fourth and fifth chapter. So this is all about this developments in the IPR. We'll try to see how one can, or we will revise related with the articles, paper, or conference submissions because it will be helpful for you in the second year for presenting your work in the conferences or submitting your work in the refereed journals. This ends our uh, topic of IPR also, and thus we can see the majorly two sections which consist of research problem, literatures, and related to technical writing. And the second part is related with the intellectual property, then its rights and protections, and what are the developments, and how we can apply the or these processes. So we stop here. Thank you.